Padrísimo, ¿eh? Muy profesionales, ¿eh?
El tema que vamos a tocar ahora en la mañana es un tema muy interesante relacionado con el restablecimiento de los derechos de patente. Creo que es un tema bien importante que nos atañe a todos nosotros, por cuanto la sanción desmedida que ocasiona de repente un error involuntario en los trámites de patente ocasiona en forma práctica fuerte la pérdida del derecho para el titular de la misma. Creo que en todos nuestros despachos siempre pueden ocurrir errores involuntarios, de repente se nos puede pasar el pago de alguna anualidad, la solicitud de presentación a tiempo, perdón, la solicitud de examen de patente o de examen de fondo de patente a tiempo, el pago de alguna tasa o la presentación de una prioridad. Y no es concebible que ese pequeño error involuntario tenga que pagarse con la pérdida del derecho de patente por parte del titular. Ahora, probablemente en algunos países donde lo vamos a ver con los panelistas que hoy me grata compartir con ustedes, vamos a ver diferentes sistemas, cómo se aplica algunas normas de restablecimiento de derechos, como va a ser en Estados Unidos, como lo va a hacer en México, y una opinión generalizada en Latinoamérica de lo que hay y de lo que puede ser. Es importante que reconozcamos, pues muchos de nuestros países ni siquiera somos miembros del PCT, por lo que no tenemos normas aplicables en pro del restablecimiento del derecho. Hay otros países, por nombrar Cuba, que recientemente en abril tuvieron un decreto en el cual se establece para la legislación interna el restablecimiento del derecho de patente, pero no hay una regulación todavía o una reglamentación de su aplicación. Pero por ponerles un ejemplo, en esa normativa interna dicen que puede restablecerse el derecho de patente de aquellos errores que no le sean aplicables al solicitante. Entonces, ahí hay un debate de qué pasa, qué no pasa, si es el despacho el que tramitó, el que no presentó una cancelación de alguna anualidad, el que tuvo un tardío pago o hubo algún tipo de error y que por un día se hayan equivocado en la presentación del documento. Creo que entonces es desmedido que se sancione al titular con la pérdida del derecho. Vamos a iniciar la ponencia de hoy con el doctor Jeffrey Lewis. Él es el presidente de la American Intellectual Property Law Association, AIPLA. Es miembro de la firma Patterson, Belknap, Webb & Tyler. Es ingeniero químico, abogado de patentes, concentrando su práctica en litigios sobre asuntos relacionados en materia de patentes. Se graduó cum laude en el Benjamin Cardozo School of Law. Ha representado a titulares de patente y ha efectuado muchos litigios en contra de infractores de derechos de patente. Ha representado a empresas químicas, farmacéuticas, así como de otras áreas tecnológicas. También regularmente asesora a clientes en asuntos de propiedad intelectual, incluyendo la provisión de dictámenes formales y los representa en sus correspondientes transacciones. Se ha desempeñado como profesor adjunto de Derecho en el Benjamin Cardozo School of Law y ha impartido un seminario sobre biotecnología y derechos de patentes farmacéuticas. Es presidente de la seccional del branch de Estados Unidos de la Asociación Internacional para la Protección de la Propiedad Intelectual, de la AIPLA. Es miembro del Federal Circuit Bar Association, de la Licensed Security Society y del American Institute of Chemical Engineers. Ha actuado en representación de demandantes y demandados en casos de infracción de patentes en las áreas farmacéuticas, químicas, biotecnológicas, en métodos de negociación, así como en la preparación de opiniones sobre la patentabilidad, validez y exigibilidad en casos de infracción. Ha actuado en diversas disputas relacionadas con marcas comerciales, secretos comerciales, contratos de trabajo, contratos de productos y procesos de desarrollo. Realmente, conversando con él esta mañana, me ha dicho que su fuente básica de la práctica es el litigio en materia de patente y nos va a esbozar un poco lo que es el proceso de restablecimiento del derecho, qué se acepta, qué no se acepta, en qué casos se acepta en los Estados Unidos, con ejemplos prácticos para que veamos cómo es la aplicabilidad de la norma. Jeff.
Gracias. Buenos dias. And thank you very much for having me here at E.C.V, where I've had the chance to see many friends who are long-standing, many friends who are brand new, and most of all, thank you for letting me address you in English. We're talking today about mistakes that happen, and mistakes happen all the time. It's not necessarily a bad reflection on the lawyer or the agent. Mistakes happen, and that's what I want to talk about. Yesterday morning, I was having a lovely breakfast upstairs, and I went to the omelet counter, and I did not know how to say one of the particular ingredients. So I said, "Cómo se dice?" and I pointed to it, and the gentleman told me how to say it in Spanish. I repeated the word. I clearly repeated it wrong. There were 5 or 6 people standing around. They all laughed, and the women started to blush. So I don't know what the word was, and I'm certainly not going to try and say it now. But what I want to talk about is how we deal with the loss of rights. That's the topic for today, and it happens not necessarily because somebody intended to lose it. It happens because of the accidents, and that's what I'm going to talk to you about. I'm divided into 2 sections. One is talking about the law and pending legislation, and the other is examples. Based upon the time today, I'm not sure I will get to the examples. They are there because I think it only makes sense when you look at the question in the context of examples. The presentations are available, and I don't think I'll get to all of the examples, but you can certainly look at them on your own to help understand. The issue, of course, as the topic heading is the Paris Convention. And in order to obtain the rights of the Paris Convention, you must file the subsequent applications at the national levels within, you must file within 1 year, 12 months for patents. This is summarized in our Manual of Patent Examination Procedures in the United States, as the U.S. Receiving Office gives 2 additional months to cure a failure to file. So if you don't make it within 12 months, you get 2 additional. The standard set out by PCT is in spite of due care or unintentional. I will talk about that in a moment because that is at the PCT level. It is not true at the United States level, and that's where problems come in. There is a treaty, I will call this a new treaty as treaties go, from the year 2000, the Patent Law Treaty, which the United States is a signatory to, that allows for 2 reasons to restore the loss of rights if it didn't happen within 12 months. And I've added the numbers 1 and 2 it read down at the bottom of the quote. You can restore rights for up to 2 additional months if you can show that due care was taken or the mistake was unintentional. I'm told that our friends in Germany tell us that if you say that a lawyer was involved and handed it off to a non-lawyer, even a non-lawyer professional, that means due care was taken, and obviously the non-lawyer professional made the mistake. But this is what we try to analyze in terms of restoring the rights. The problem is, and comes up, that each contracting party can set their own requirements. And that affects how the application is treated when it's converted to the national phase after the 12-month period is over. So after you filed your PCT application, you have 12 months to move it into each of the country phases. And in the national phase, if you miss that 12 months, even by a day, then the issue becomes, how do we restore patent rights? In the European Patent Office, for instance, they will allow restoration if you can say due care was taken, but they do not allow restoration of rights if it was unintentional. So if you can put in a sworn statement that says, we tried to make the date and there was a snowstorm, for some reason the mail didn't work, our computers failed, there was a blackout, due care was taken. If you just put in an affidavit or a sworn statement and you say, oops, we meant to, but somehow it didn't happen, there is no ability to restore rights in the European Patent Office. The United States is, of course, exactly the opposite. In the United States, we excuse an unintentional error, but we do not recognize any effort at due care. So this means, and our MPEP, our Manual of Patent Examining Procedures, lays this out in terms of what happens in our International Bureau, our receiving office. It says that it's in spite of due care and unintentional standards, but if you look at the last two lines, the USPTO, the United States Patent and Trademark Office, only decides these matters under the unintentional standard. What this means is, if you come into the United States and you put in a sworn statement that says, I promise you it was unintentional, you lose European rights. If you instead say, oh no, due care was taken, you lose United States rights. Now, as complex as this is, WIPO does try to help us, and they have a matrix, they have a large chart that lays out in a country-by-country basis what happens. So if you actually go to the WIPO website, it's a wonderful resource, and it will tell you what happens as a receiving office, so on the PCT standard, and then as a designated office, that's the national phase. And you'll see that in the United States, yes, you can restore on the PCT level, but no, you cannot restore on the national phase level. And of course, as I told you, on the EP, you'll see that you can restore on both, but it's only due care. Now, of course, as all of our governments are wont to do, WIPO also very generously tells us just how much the honor of restoring the mistake will cost us. In the United States, it's $1,410 and is about to go up. In Europe, it is €580. And I don't know what's happening in Europe, but I'm going to take a guess that it's going to go up. But that is what our governments do. Now, I mentioned that there is this patent law treaty from 2000 that the United States has signed on to, but as with all legislation, and I experienced this last week when I was in Cuba, and they were talking about their new patent legislation, once the legislation is enacted or the treaty is enacted, nothing happens until somebody sets the rules to make it work. So in the United States, we're looking at the PLT treaty, and there is a 2012 bill, so it's very current, called the Patent Law Treaties Implementation Act. It was introduced in August. What's very significant, if you've been following the United States government, is you'll see that it has two sponsors. Senator Leahy, who is a Democrat, that's the blue D, and Senator Grassley, who is the red R. This is an amazing thing that we have both a Republican and Democrat sponsoring a bill in this day and age in the United States, because nothing is happening in our Congress. They're too busy fighting with each other. But they have co-sponsored it, and it implements two different treaties, the PLT that I mentioned, and also the Hague Agreement on the registration of industrial designs. But for our purposes, what you need to know is, despite the fact the Patent Law Implementation Treaty was submitted in 2012, the good news is our Senate has passed it. The bad news is our House of Representatives has not yet taken it up. The House of Representatives seems to be where the biggest fights are happening between our two major political parties, the Republicans and Democrats. So I have lots of hope, but little faith that this will be finished before our Congress adjourns in January. The new Congress is seated, and any bill that has not been passed dies automatically, and this will all have to be started again. So as I say, it's not yet enacted, it's not law, but my best guess as to what the law will be when enacted, if enacted, is that it will implement the PLT. The current language says it will implement the PLT. Section 119 of our U.S. Patent Code talks about the benefit of earlier filing dates. The current law says that both domestic, which means the United States applications, and PCT applications, you can get the 2 additional months if the delay was unintentional. That is where the absence of the due care standard is. That is why we cannot apply the due care standard in the United States, is because Section 119 does not discuss it. If PLT is enacted, what we will end up with is the ability to restore for both due care and unintentional on both the PCT level and the national level. So that will then allow people to restore their rights under the Paris Convention and not have to worry about the United States as a problem. As I say, this makes the most sense, and I think it's all very well and interesting to chat about, but until you actually look at examples, it's a little tough to get your hands around. So perhaps for a moment or two, while I still have a couple of minutes, I'll start walking through the examples, and the first of which is a Brazilian-filed PCT, where they missed the 12-month window for going into the national phase. If you look at, again, the matrix that is available on the WIPO website, you'll find that Brazil does not allow requests to restore rights, either at the national level or at the PCT level. So what is a Brazilian inventor who has, or more likely the Brazilian attorney, who has this problem going to do? The solution is that you can still file a request to restore the rights, either for unintentional or for due care. And the other good news is there's no fee if you file it in the WIPO office as opposed to the national levels. The problem may be solved at the PCT level, but it's still not solved at the United States level. You will never be able to regain those rights in the United States because you have not the ability to cure that 12-month problem. A variation on this is what happens if instead we're dealing with a United States inventor and the PCT date is missed by 1 day. Again, in the United States, you have the problem with our filing office, but you can file a request with WIPO, International Bureau, no fee, and identify the error as either unintentional or despite due care. And while that will not be recognized in converting the WIPO application, the PCT application, I should say, it will not be recognized in converting the PCT application into the U.S. national phase, there is the ability to instead file a brand new U.S. domestic application, a full utility application, and claim priority with a petition for the inadvertent failure to meet the 1-year date. The petition will likely be granted, and so for United States purposes, there is the ability to solve the problem. But in the United States, we require foreign filing licenses to do international filings. And so there may be the situation that you don't have that export license. You can't go to the WIPO International Bureau to request leave. So you might still be able to cure for the United States, but you cannot cure for purposes of the U.S. domestic application by going to the International Bureau. There are still situations where you can cure the problem by filing an unintentional request in the U.S. receiving office at the PCT level, filing a domestic application for the U.S. level. But of course, as I've mentioned, the reason that that causes a problem is in the U.S. receiving office, you have to say it's unintentional. So you may still have surrendered any ability to convert to the national phase in Europe. And so that becomes a problem. I would suggest to you one final hypothetical in my 7 seconds, which is that the national application is missed in the United States. You've missed the filing date. You can never solve that in the United States unless this new bill is enacted. So with that, I will turn the podium over. I hopefully haven't gone more than a few seconds over my time. What's a few seconds between friends, huh? And I do suggest to you the other examples would be helpful to understand this topic.
Thank you very much, Jeff, for your clear presentation. It was very interesting, all the example that you have shown us and how to fix it according to the patent law. Continuamos con la siguiente presentación del doctor Eugenio Pérez, miembro de la firma Uhthoff, Gómez, Vega y Uhthoff de México. Es ingeniero industrial y de sistema, socio de la firma de abogados Uhthoff, Gómez, Vega y Uhthoff. Su formación se ha realizado en materia de ingeniería industrial y de sistema en el Instituto Tecnológico y de Estudios Superiores de Monterrey, en el campus de la Ciudad de México, graduado en el año 98. Tiene un diplomado de propiedad intelectual e industrial impartido por la Facultad de Derecho de la Universidad Panamericana. Tiene publicaciones como son la Geografía de las Patentes en la revista Mi Patente de México el 2007, en el File and Patent Application México. Tiene actividades como profesor adjunto a la Universidad Iberoamericana impartiendo la materia de Derecho de Patentes y el procedimiento